Immigration courts. When you look up the word, articles pop up about a doomed system that has failed time and time again to properly manage itself and others in the wake of a recent immigration crisis. So it is no wonder why there is such a demand for change. However, in changing the courts, should speed and efficiency be favored over diligency and hard work? The answer is no. First of all, what is the current problem with our immigration courts? Immigration courts are defined as an administrative court that hears removal and deportation proceedings. According to the Immigration Court Backlog Tool, in 1998, cases numbered roughly over 100,000. As of 2018, there was a current backlog of roughly 700,000. But what option can we turn to fix this mess? Option is to establish an Article 1 immigration court. This kind of court would be separate from under the current jurisdiction the immigration courts are under, aka the Department of Justice. This would allow the courts to manifest into a separate neutral branch under Article 1 of the Constitution. However, the Trump administration argues that this current system's backlog can be fixed if the government speeds up the process of the courts, rendering the idea of a new system useless. But will this kind of approach really work with a legal system that is so convoluted and complicated? An Article 1 immigration court is simply the best thing to do for the current state of our courts, but only by educating others of the current state of our system will we be able to successfully implement it. Moreover, the situation concerning the reform of our immigration court has become so prominent, even the court's own judges are speaking out against it. According to an article in the Washington Post, written by current immigration judge and president of the National Association of Immigrant Judges, Dana Lee Marks, she states that a number of lawyers, organizations, and scholars agree and endorse the creation of an Article 1 immigration court. It would allow a reliable funding stream from Congress to assure we have the resources needed to address our burdensome caseload in a timely manner. It would mean that neutral judges would use their skills to make the rules and assure a level playing field for all. An independent immigration court will be an efficient and effective court. Dana has been in her field for a long time, and clearly she has done well. That means she knows what she's doing. Alongside lawyer organizations and scholars, her reasons are clear of why she advocates for the creation of an Article 1 immigration court. And if someone so high up on the chain believes in this system, without any doubt, we can take confidence that this is the right direction to go toward. Furthermore, a huge issue with our current immigration courts are that they are heavily burdened by a lack of resources and time. In the same article, Dana also talks about the strenuous problems immigration courts face and the pressure they are constantly under. Quote, "The volume of work can be overwhelming. Some of our judges carry caseloads of 5,000 cases or more, usually with limited support staff. Beginning in October of last year, judges were ordered to complete 700 cases each year or risk losing his or her job. This is not how a court should be run." It is clear that the lack of resources that are available to the immigration courts is making the process slow and stressful to the current judges. But if the courts fall away from under the Department of Justice, like Article 1 suggests, then that court would have the attention and direct funding from the government it would need. This direct funding could be used in hiring more lawyers, hiring more judges, overall helping the due process. In addition, the current system is so bad, it's starting to affect our own citizens. Listen to the story of Mark Little and how the system has failed him. In an article published by The New Yorker, we read the story of Mark Little. Mark Little was a disabled man who was born in North Carolina. As an American citizen, he was mistakenly deported. His trial was held in an isolated room with 30 other men with a judge on a webcam. They were asked if anyone objected to being deported, and the only record of the hearing is a digital audio recording which states that no hands were raised. He was deported to Reynosa, one of the most violent cities in Mexico, and after being discovered he wasn't a Mexican citizen, he was deported to Honduras, then El Salvador, and then Guatemala. 4 months after being deported, and 3,000 miles from home, Mark was found sleeping on a park bench by Guatemalan police. Finally, he was sent back to North Carolina. But on a connecting flight home, he was stopped in Atlanta by ICE and was nearly deported again. If we continue to let our current system reign, it will continue to hurt people like Mark Little. As shown here, the current system is sloppy and disorganized, allowing people like Mark to fall through the cracks. A new system is needed because simply the system is too far gone. Its original job of handling immigration deportation hearings have apparently turned into American deportation hearings. But the Trump administration argues that the way to fix the backlog is to have more control over the court system. According to the White House, Trump believes in a firm approach in handling the backlog. He wants to quicken the process along by tightening U.S. borders in order to decrease the flow of cases coming in, and by hastening the process of court trials, effectively causing the backlog to decrease and the courts to function properly again. However, a recent New York Times article shows that Trump's policies are showing to be ineffective. Quote, "The backlog in the immigration courts has been growing for the past decade, and pending cases have increased by nearly 50% since Mr. Trump took office in 2017. Trump's policy does not work for the system. His approach insists on speeding up the process and getting immigrants out of the country, but this would not solve the problem because the problem does not lie in the process of an immigration court trial, but rather by the overwhelming number of cases that are currently flooding the system. He is only addressing the immigrants as a problem and throwing them out of the country, when in fact the most effective solution would be to work through the cases in the system. Article 1 addresses this congestion by allowing courts to have more resources in order to work through the caseload. In fact, by enforcing his rules, Trump has only succeeded in making the initial problem increase twofold. So, to reform our immigration courts, Article 1 is simply the best option. Therefore, the important thing to take away from this presentation / slideshow / podcast is to educate yourself. Knowledge is a powerful tool, and when used correctly, it can do so much good in the world. I bet most of you didn't even know what an immigration court was before this, and that's exactly the problem. Help bring more light and support to the creation of an Article 1 immigration court, and by coming together, we can make a difference in over 800,000 lives.